Pritchett had told me in the past that, one, he's not Mr. Pritchett. He's a sovereign citizen, but he didn't want a lawyer. He didn't want the lawyer who was appointed to him. So I just need to work through whether he's going to represent himself or if he's going to work with the gentleman who's been appointed, or maybe because you're here to tell me we've hired someone for Mr. Pritchett. All right, if we could bring him out, please. Good morning, Mr. Pritchett.
Are we on record?
We are not on the record.
Get on record, please.
Not yet. Can you take a seat, please?
Are we on record?
You heard me the first time. I need you to sit down, okay?
Am I obliged to sit down?
No, you can stand. If you want to stand, I'm not going to pick that fight with you. Mr. Pritchett, I just need to figure out whether you're going to be representing yourself or if you're going to work with Mr. Bridges.
I believe there's been a mistake concerning this entire alleged case. What evidence is there to prove that I own that name and the charges apply to me?
When I know who's representing you, I'm happy to discuss those topics with you. But I need to know if you're working with Mr. Bridges or if you want to represent yourself.
Did we have a conversation before about this?
So we've had a couple conversations, but I left them unsure of what it was you wanted to do.
Does Mr. Bridges have any delegated authority to represent that name? Because I believe there's been an entire mistake. What evidence is there to prove that I own that name, and I am authorized and that the charges apply to me?
So I'll go to a different question. What name would you like me to call you?
Am I obliged to claim ownership of that name or use it as a personal identification? Am I obliged to take and claim ownership of that name?
So you're answering my question with a question, which of course is frustrating and not real helpful. I want to make sure I'm referring to you by the right name. Should I not call you Mr. Pritchett?
Am I obliged to claim ownership of that name?
All right, we are done. If you could take the gentleman in the red jumpsuit out of court, I appreciate it.
Buckle up, guys. Today we're diving straight into a courtroom showdown where an officer walks in confident, but the judge instantly locks onto inconsistencies. From the first exchange alone, the tension spikes as the officer tries to justify the arrest, while the judge's tone makes it clear something's off. You can feel that this isn't going to be a routine hearing, and the real story is only just starting to unfold.
Ms. Rivers, were you able to stay on?
Yes, Judge, I'm right here.
Thank you so much. Lunch break in just a little bit. Let's go on the record in Mr. Pritchett's matter, which is, just move my calendars around, 20 SC 176922, State versus Max with 2 X's, Pritchett. And originally we were going to have a status conference where I would hear from Mr. Granums, who had been appointed to represent Mr. Pritchett, about how things were going. But Mr. Granum shared with me that number 1, he had not yet received discovery. And number 2, more important in some ways, he had not yet had a chance to meet Mr. Pritchett. So I said, let's reset this. Then I got a note from one of the deputies that Mr. Pritchett wanted to talk to me. So here I am, and we are on the record. So Mr. Pritchett, good afternoon. It's August 5th. What do you want to share?
On the record, I believe there's been a mistake. Am I being forced to claim something that is not mine? Where is the proof again of evidence that legal name you're assuming me to be belongs to me? Also, on the record, let the record show that Michael Granums and any other false advocate forcibly and deceptively assigned by this court is hereby dismissed. Furthermore, if there any evidence that I am prohibited from having as my advocate and representative, Jesus the Christ, that is mentioned in the Holy.
All right, guys, here's where the judge starts tearing into the officer's version of events. Every time the officer attempts to explain, the judge slices through the excuses like a razor, demanding specifics he clearly doesn't have. The room gets heavier as each question exposes another crack. By this point, the judge isn't just skeptical. He's openly doubting whether the officer even understood the law behind the arrest.
Are Max Pritchett, but you're not the Max Pritchett who should have been charged in this case. But that's not something that I need to work through.
Where is the evidence? Does the prosecutor have the evidence? So can they please provide that?
So that's where we get to your last question about representation. Mr. Granums won't be your lawyer if you want to represent yourself in concert with the Lord Jesus Christ. he, the Lord Jesus Christ, probably can't do a whole lot of advocating on your behalf because I don't know that anyone would hear what he had to say. But you are always free to represent yourself, and we can have a conversation about that at the appropriate time. But we always stumble on that first part where you want me to provide evidence. And I've explained that that's not my role in this process.
Whose role is that?
Well, the prosecutor has the burden of proving your guilt beyond a reasonable doubt. If they're able to do that, and they either prove it to me if it's a bench trial, or they prove it to a jury if it's a jury trial. You've been through that before in your probation revocation, where the prosecutor proved to a judge that you had violated the terms and conditions of your probation, and you got the sentence you got from that judge. So we do a process somewhat like that.
Does the evidence exist?
I don't know. If it doesn't, then I know what the jury will do. They'll acquit you, and you'll just be working through your revocation. But I don't.
How can we proceed with anything? On the record, how can we proceed with anything if jurisdiction and authority has not been established or proven beyond?
Now things explode into full sovereign citizen mode. The defendant drops bizarre legal claims, insisting statutes don't apply to him, while the judge fights to keep the room under control. Every argument spirals deeper into nonsense, and the judge's patience thins fast. You can practically feel the frustration radiating as the courtroom becomes a battleground of real law versus imaginary rules the defendant swears are binding.
It gets proven beyond a reasonable doubt at trial. That's when the jury decides if crimes occurred and if they occurred in Fulton County. If they didn't occur at all, or they occurred but it wasn't in Fulton County, then there's no more jurisdiction, and you get to go back to dealing with your revocation. But what we need to sort out is who would be representing you. You're telling me you don't want it to be Mr. Granums, and we can make that happen. I'm going to have Mr. Granums come meet you. You can tell him to go away or break bread with him or whatever it is you choose to do. But I need the two of you at least to have that initial contact. So he's going to come visit you, and then he'll, I'm guessing, share with me what you shared with him, which is what you shared with me. And then we'll get you back here and have that discussion about self-representation with the Lord as your standby counsel, which we can do if that's how you want it to work. Anything else you want to get on the record?
Just that if the evidence exists, can you please have the prosecutor or whomever that does have this evidence, that I am the legal name that this court is claiming me to be, and just please provide me with the evidence of that, and also the evidence, if it does exist, once again, of the jurisdiction and authority of this court, and that it does have jurisdiction of authority over the body and church of Christ, which is composed of individual members such as myself.
Got it. If you end up representing yourself, then the prosecutor is going to need to give you all their evidence. Once you get that, you'll be in a position to say, you know what, I think it's deficient, and here's what we need to do. But until we sort out that you're going to represent yourself, again, with the Lord as your standby counsel, the state needs to be working through Mr. Granums. I heard you very clearly, no misunderstanding on my part, that you seek to dismiss Mr. Granums. He's going to come talk to you. You can tell him the same thing. We'll bring you back and have that hearing about representing yourself. Okay? Good seeing you.
At this moment, the judge turns back to the officer with laser focus, piecing together every contradiction. The officer tries to stay composed, but his answers start collapsing under pressure. Each clarification only makes the situation look worse, and by now the judge seems convinced the arrest was mishandled. The tension is sharp enough to cut through, and everyone in the courtroom knows the tide has completely shifted.
This is about what we just talked about?
Oh, yeah.
Okay. Well, look for that lawyer to pay you a visit in the next couple of weeks, okay?
Yes, yeah.
All right, you're free to go. So, Mr. Pritchett, I won't interrupt your biblical readings. We actually just needed to talk to Mr. Robinson today. You've made your desires very clear, but since they put you in one of the cells, I didn't want to miss the opportunity to see how you were doing and let you get back to your reading. Mr. Hiles, anything in Mr. Pritchett's case?
No, Your Honor.
Okay. All right, Mr. Pritchett, you are free to go. You're free to stay.
This is the moment everything comes crashing down. The judge delivers a blunt, unforgiving conclusion, calling out the flawed arrest and the officer's shaky testimony. The defendant stands stunned, and the courtroom falls into a heavy silence as the reality hits. It's the kind of ending that leaves no room for confusion. Just a powerful reminder of what happens when the truth finally takes center stage. Make sure to like the video and subscribe to the channel, and we'll see you in the next video.